Hello, law seekers! This video is especially for every lawyer and compliance officer. It addresses a critical and immediate responsibility that you hold. We will discuss the United Nations Sanctions list. More importantly, we will discuss your professional duty to monitor it. The core message is urgent and direct. Risk is present now. You must act today. In our complex global economy, ignorance is not a defense. It is a liability. Your clients depend on your diligence, and your firm's survival relies on your vigilance. The rules have changed. The stakes have never been higher. Your role as a gatekeeper is fundamental to the integrity of the financial system. When you advise on a transaction or onboard a new client, you are on the front line. You are tasked with preventing illicit funds from entering the legitimate marketplace. The UN Sanctions list is one of your most essential tools in this fight. Let us first define the United Nations Sanctions list in straightforward terms. This is a consolidated list maintained by the UN Security Council. It names specific individuals. It names specific groups. It names specific companies. It names entire governments. These parties are designated because they are linked to activities that threaten global peace and security. Terrorism, nuclear proliferation, armed conflict, severe human rights violations. When the UN designates an entity, it triggers a global obligation for member states to impose strict measures. These measures isolate the designated parties from international financial and trade systems. The primary purpose is to apply pressure on the designated parties. The goal is to compel change without military force. The most common measures include asset freezes, travel bans, arms embargoes. For you, the asset freeze is the most relevant and immediate concern. It legally requires all nations, and thus all financial institutions and businesses, to freeze funds or economic resources of a listed party. The sanctions list is updated as needed, with the most recent updates made in October 2025. It was a significant revision that added new individuals and entities from specific countries. Iran and Haiti figures prominently in this update. It also amended the identifying information for several existing designees. This means that a previous screening that resulted in no match could now produce a direct hit. The risk profile of your entire client base and all your active matters may have fundamentally changed. Your due diligence files from September 2025 are now obsolete. This matters to you as a lawyer or compliance officer. You are responsible for conducting due diligence on your clients and their counterparties. Imagine you are facilitating a corporate merger. You checked all parties involved 3 months ago. If today, following the October update, a key shareholder of the acquiring company is now a designated person, and you proceed with the transaction, you could be facilitating a sanctioned activity. This would place your client in violation of the law, exposing your firm to severe penalties for its role in the process. The impact extends beyond your immediate clients. It affects their entire business network. If a critical supplier or its owner is now on the UN list, your client can no longer legally pay them. Failing to comply with UN sanctions is not a minor administrative error. It triggers a cascade of severe and tangible consequences. These consequences fall into 3 main categories: financial, legal, and reputational. Each can be devastating on its own. Together, they can destroy a business and end a career. Let us be clear about the specific penalties. These are not hypothetical risks. The financial penalties are often the most immediate and shocking. Regulators can levy substantial civil fines against firms that violate sanctions rules. These fines can run into millions of dollars. Beyond fines, there are asset freezes. If your client's funds are linked to a sanctioned entity, banks must freeze the account. This happens without warning. The money becomes inaccessible, crippling your client's operations overnight. Your invoices for that work may go unpaid. Sanctions violations can lead to criminal charges and ethical complaints. This moves beyond corporate liability into personal liability. Lawyers, partners, compliance officers can face prosecution. The risk is clear, and the consequences are severe. Now, let us focus on the solution. You can significantly reduce your risk by implementing a clear framework of proactive measures. These are not complex or expensive steps. They require diligence, consistency, and commitment to making compliance a core part of your workflow. The first and most fundamental step is to integrate sanctions screening into your client onboarding process. Before you formally accept new clients, check their names and check the names of their key beneficial owners against the latest UN list. Second, screening cannot be a one-time event. You must conduct ongoing monitoring to ensure that a beneficial owner of funds is not on the list. Rescreen all parties before the final transfer of funds, so you can stop the deal if necessary, and protect yourself from ethics complaints, regulatory fines, or perhaps damaging media stories. Third, you must leverage technology, but also train your people. Use a trusted professional screening tool that updates in real time. Do not rely on manual searches of websites. Your entire team must be trained on what to do if they find a potential match and to whom to escalate the issue. Finally, your mantra must be, document everything, every time. If you found this video useful, then please like, share, and subscribe. See you for the next one.